Welcome to the webinar. You have entered as an attendee in
Good afternoon, everyone, and welcome to our webinar, Marsys Law, Exploring the Legal and Practical Challenges. Before we really get underway, we're just going to give it another minute or two for some other people to join us, so please be patient.
People have these down here for the visuals, so they can see us, or is it all off this record?
And
Okay.
We're on the other screen. It's hard to see from here.
Okay, everyone, welcome to the latest webinar from the ABA section on civil rights and social justice, as well as the ABA Standing Committee on Legal Aid and Indigent Defendants. If you like this work, we invite you to become a member of the ABA and the section on civil rights and social justice to collaborate with us on projects you want to develop and offer to our members and the general public. During today's program, you can ask questions of our panelists by finding the questions drop-down box on the right-hand side panel and typing in your questions. I will be moderating today, and I will find time at the end to ask our panelists to address the questions we see. Also on the panel, the menu is a handouts drop-down where you can access our written materials. We'll be sharing a recording of this program with the handouts to everyone who's registered so that you can share it widely within your networks. Please feel free to leave us feedback or ask questions and follow-up. We are thrilled today to be able to present a program on Marsys Law, Exploring the Legal and Practical Challenges. My name is Malia Brink, and I am Public Defense Counsel for the Standing Committee on Legal Aid and Indigent Defendants. Our panelists today are Tracy Smith and Ryan Kolbeck, both from South Dakota, and we're going to be focusing today on South Dakota's experience with Marsys Law. Tracy Smith is the director of the Minnehaha County Public Defender's Office. She's been with the Public Defender's Office since 1999 and became director in 2005. Ryan Kolbeck was with the Minnehaha County Public Defender's Office. He was also instrumental in forming the South Dakota Association of Criminal Defense Lawyers and opened his own law firm, the Kolbeck Law Office, in 2017. So with that, I'm going to turn it over to Tracy and Ryan to take us through the history and implications of Marsys Law for public defenders in South Dakota.
Thank you.
Well, I think we're going to begin here, and this is Ryan, and we're going to talk a little bit about how Marsys Law came to play initially here in South Dakota, some of the problems with the original version, how it was changed about 2 years ago, and then where we stand today, determine whether or not any of the changes and impacted us in a positive way or a negative way. I would just state that this is kind of cool being here because Tracy hired me and we were just laughing about that in 2006. And I had a lot of great experience in the public defender's office where we started the South Dakota Association of Criminal Defense Lawyers. And how I believe I got involved with Marsys Law was that people were looking at each other saying, this is a terrible idea, but the only organization that really stood up was the Criminal Defense Lawyers Association of the Public Defenders. So it was proud to be a part of that group and those two groups here in the state of South Dakota. I would state that I think Marsys Law really began, and the energy, I guess, the fuel for Marsys Law probably started in 2010. At that point in time, we had a governor in South Dakota. His name was Mike Rounds. He's currently a senator. And when this all happened, he was our governor, and he commuted a sentence of an individual who shot his girlfriend out in Pennington County in 2010. The victim's family was not notified. The victim's family was not aware of this commutation until it came out in the press. Governor Rounds mentioned that they did not have updated information for the victims' families. They could not provide contact or information because they didn't know where to contact them at. And either way, it was one of those situations that was done. This life sentence was commuted to, I think it was 175 years. So it's not as if the person just walked the streets that day, but he was going to be eligible for parole. And back in 2010, this was something where people were upset. Politically, I think he took a little bit of a hit, but according to the statutes, there wasn't anything anybody could do. And I think that's ironic because even with Marsys Law, the way that it is now, if that were to happen today, there is still nothing that anybody can do, just because sometimes those things occur. What we had, though, was people that felt slighted, people that felt as victims and didn't get noticed and didn't feel part of the system. We really didn't hear a whole lot about it, though, for some time when, I don't know if you guys' states are like South Dakota, but South Dakota is comparably a very cheap or inexpensive state to do initiatives and referendums and petition for both law changes as well as changing our Constitution. We are one of the first states to do it and first states to allow for the referendum process. And basically it's giving people the power to vote and to change the law, change the Constitution as they see fit. We're a cheap state in the sense that our media and our television commercials and the mass mailings and even the publications and things of that nature are very cheap to produce and very cheap to get to the 707,000 total people that we have in our state. I think it's relatively expensive compared to a lot of other states to do this. So what we've become is a test area, a test state, where a lot of out-of-state money comes in, and in this case is a perfect example. They buy up the airways, and then they get on the ballot, and then all of a sudden now they go to other states saying, look, South Dakota did this, you should too. So we're one of those first steps. So really we're a pawn, we're being used, and it really bothers a lot of people. And frankly, this was the perfect example of the politics of fear, marketing, and going to people's emotions, all kind of tied up into one, along with a California billionaire, to get this thing passed. I can tell you from my experience that I try to stay in tune with everything that I can, but this got on the ballot with hardly anybody knowing about it. So what that means was they had to go and get their percentage of the population, get signatures, and they did that at state fairs. They did that at very low-key events. So that all of a sudden, they're going to the Secretary of State's office with
Ryan, hold on a second. I lost audio. I don't know if anybody else did. Okay, Ryan, I'm going to ask you guys to just cut your phone line and dial back in. Bear with us for just a minute. I've actually never had that happen before.
There?
Yes, we can hear you.
Okay,
Sorry about that.
So pretty soon we're on the ballot, and that was the first time that really I even recognized what was going on. And this was in the summer then of 2016. We had our lawyer convention at that point in time. It was in the middle of June. We spoke, I spoke, and a former assistant attorney general spoke. And I still remember basically the main theme talking about how this was going to become a tool for vengeance rather than how the criminal justice system should be ran. Prosecutors are going to lose power. We talked a little bit about how civil cause of actions and also the burdens that are going to come. The state bar, basically everybody but one voted against this and said that we should come out and oppose as leaders in our community. The one person that voted for the Marsys Law was the director of Marsys Law for South Dakota and the legislative person who was being paid to push this. So then we work at it. We contacted the prosecutors. I think the Pennington County and the west side of the state was much more vocal than any other prosecutor in the state. We went to the editorial pages of our newspapers. We went to our local chambers of commerce. We went to the state chamber of commerce. We went to the counties. I went to myself and the former AG to Minnehaha and Lincoln County, which is probably 35–40% of the population in the state of South Dakota. We went to those county commissions, talking to them about what this was going to do. Those county commissions all opposed Marsys Law in a vocal manner and attempted to do basically what they could. And then we hit their media blitz, where they put in over $1 million of media commercials and ads. And they are the marketing geniuses who came up with the scary music and the dark videos. And people thought that after watching that video that they were all going to get killed unless they voted for this. And they also had Kelsey Grammer came in talking about some incidents that happened in California and things of that nature. And then it was something where their budget was, over $1 million to ours, I think, had $700, which was something where it was really hard to raise money to get anybody to spend money on this when we know that we're up against millions of dollars. And how are we going to even play in that game? Most of it was our own contributions. We did have a Facebook page that was vocal. Now, I brought up the Rainbow situation because their only link to a local issue that they could find was that commutation in 2010, which was some 6 years before this ever happened. So that is kind of how they try to make it local. Besides, no other victims groups in South Dakota wanted it. The counties were all against it, chambers of commerce. We had the business community, we got prosecutors, we had a lot of weird coalitions. Everybody was against it locally, and it passed, though I think it was 80-20 essentially that it flew by. And then we had to deal with it. And immediately afterwards, obviously people are wondering what to do. And I'll go with Tracy as far as that goes.
So some of the problems that we experienced mainly was blocking access to records. We had a difficult time obtaining discovery. Our paralegal was actually served a cease and desist from the Attorney General's office for leaving 2 voicemails on the machine of an older woman who our client was charged with grand theft, where the situation was, there was an issue of whether or not she had written him checks for services he had done for shoveling snow, doing lawn work, or whether or not he had stolen these checks from her home. He was a neighbor, and the paralegal simply left her 2 voicemails, and we received a cease and desist. So there was this sort of fear factor of what happens when there's a violation of Marsys Law. Another incident we had was an attorney in our office had to file a motion and brief and have a hearing because the state wanted to preclude us from conducting a scene view, taking any photos at a home because a witness or an alleged victim didn't want us having access to her home or was claiming that we were violating her rights. Other issues that we have seen are access to contact information for witnesses, for alleged victims. We had a situation, one of the big things we see is a lot of delays in trial where
I'm sorry, Tracy, I can't hear you again. Tracy, are you dialing back in again?
Yep.
Yes.
Can you hear us now?
Oh, perfect. Yes, yes.
We did a different phone, so this one shouldn't have dropped connection. I apologize.
So access to contact information where the state was not willing to, they claimed that they needed a delay where we knew that the victim wasn't cooperating and she had moved out of state. Well, the state wasn't willing to provide us updated contact information claiming Marsys Law so that they didn't have to provide it. Other issues that we're currently seeing, and Ryan can talk a little bit more about the changes that were made, is who's the victim? We have issues where is it law enforcement a victim? Is Walmart a victim? When somebody steals something from Walmart, who exactly is the victim? A part of Marsys Law is the notification requirements. So you see a lot of delays because the state is claiming they have to give notice. So you have issues with bond hearings. I've had situations where I have a client who wants to plead guilty and the state says, oh no, they cannot take this plea agreement and plead guilty today, which would have been credit time served, because they have to give notice to the victims. Other issues that we see are simply the rising costs. I think it's safe to say that violent crime hasn't gone down. This hasn't resulted in a delay in cost by any means. It hasn't resulted in us having a safer community by any means. Right after this was implemented, the state's attorney's office right away needed significant numbers of additional staff members. They needed victim witness assistants to help them contact all of these alleged victims to notify them of every single court date. We have a duty to notify every client of all their court dates every day, every week, but this is something they weren't used to. So now for every single court date, they had to send out notice and talk to them about what they wanted to see happen. Eventually, the state created this save-in system to help with the notification requirements. We also saw a significant delay in court appearances, and it resulted in a significant increase in clients being held in jail pre-trial. The concern there is many of our clients are also victims. If they're held in jail, they're losing their housing, there are issues related to their kids. We actually started tracking eventually the number of people who are held in jail pre-trial versus serving sentences, and we were able to produce numbers that showed that only 22% of the people that were actually in custody were actually charged or sentenced for a violent crime. The rest of the people that are sitting in jail are simply waiting their pre-trial. I think it's safe to say that a significant number of those are related to the additional delays from having to do the notice requirements, allowing people the opportunity to be present. Did you want to talk about the changes with defining who's the victim?
Yes, the original Marsys Law had a very broad definition, and basically two parts to this. First of all was that the rights were given to the victims at the time of victimization. And that was one thing that was debated, because how do you know for sure if you're a victim if you don't even know? If I was out of town and my house got vandalized at the time of victimization, no, I now have these rights. That was modified, but basically only after an attorney general opinion, because what we had were certain prosecutors said that it happened basically instantaneous. Certain prosecutors argued that it didn't happen until charges were filed. The attorney general had to convene a little task force after Marsys Law was passed, and I always thought it was funny that the first person that was on that list was the one lawyer that wanted Marsys Law, but I guess it's appropriate in that regard. First thing that he did, though, was basically write in the Constitution an opt-in provision, where the victims must opt in to the rights of Marsys Law. And we talk about activist judges and things of that nature, but this is not in this text, but it's something that he just basically gave an opinion on so that counties who wanted to rely upon it could, and hopefully, in their opinion, not get sued. So that was the first change that needed to be made. Secondly, we had the greater definition of victimization was basically anybody who suffered psychological or financial harm as direct or threatened physical, psychological, or financial harm as a result of the attempted commission of a crime, as well as a number of close family members who were defined, but then also anybody who just had a relationship that was similar to being a close family member. So it was really difficult to figure out whether or not that neighbor, who was kind of like an uncle, is a victim. And how are we supposed to go figure out who these people are? Because they're basically just kind of vague, mythical individuals who, we're cousins, but we're kind of like brothers. So I have a relationship that's just like a brother. So therefore, I have the same rights as the actual victim themselves. And that was where people were just scratching their heads saying, how do we notify all these people that we don't even know? We don't know where the real victim is, let alone their parents, their siblings. They're substantially close to those individuals in their relationships, and who these people really are.
And the frustrating part about that, too, is when you do motion to sequester people from the courtroom, there is an exception to that where victims are allowed to stay. They're not subject to sequestration. So that's a problem when somebody's grandma, sister's uncle is saying, well, I'm a victim too under this, and I should get to stay in the courtroom.
Especially when they're also witnesses.
Yeah.
Directly to the case.
So that's frustrating. Other problems that we have with this are, victims' rights advocates. They receive money from the county and, from fundraising to support people who are victims of crime, but they are allowed access to police reports, but they also are required, our clients, if they're convicted of a domestic abuse crime, they have to obtain treatment. A lot of the advocates were coming out in support of us not having access to discovery, but still treating our clients. So there was more of a conflict of interest with a lot of the local organizations who were actually, saying, well, you can't have the school records because they actually now had counsel, even though Marsys Law does not provide for the right to counsel through these groups. Where we're at now, Ryan and I have been having meetings with the court and the state's attorney's office. We've had a couple meetings so far, is our ability to disseminate or provide our clients with discovery. That's one of the big focal points that we've had right now is, can we give our clients police reports? And so we've been trying to fight a lot of battles related to that.
Most of the time in my opinion, there would never be an issue, but they say that the right to privacy that's within Marsys Law means that we can't even get their contact information, let alone give it to our clients. So what changed? When we basically had these issues come about, we had to have an attorney general opinion. The next legislative session, people were basically saying that, oh wow, those people were right, saying this was going to cost the counties more money. In Minnehaha County, it was costing $400,000 a year more. Pennington was $300,000. The state had to go get another $600,000 in their budget, which they said was directly as a cost or as a result of the rising cost due to Marsys Law. So they passed a resolution, which was done in the legislature about March of 18 then, and then put a House resolution that made it on the ballot another version. And this is basically where I talk a little bit more about their marketing, because they say this version, which is now Amendment Y, was, they say, stronger and better for victims and things of that nature, when in fact it had about three major key components that, technically speaking, were worse than victims, in the sense that the first thing they did was, in this Amendment Y, was narrow the definition of victim. So we no longer had these mythical individuals that had a relationship that was close to being a brother included. It was much more direct. It's much more narrow. Now it is more just the victim themselves. Secondly, they basically enshrined in the Constitution that opt-in provision that the Attorney General made up that was not a part of the first version. So that is now basically the law of the land, something that they decided that they wanted to fix. And third, they included a provision in there that basically granted immunity to the state and the counties if there were any violations of Marsys Law. Because, and I'll be honest, I actually sued a county under violation of Marsys Law before this happened, based on something, mainly because I was just pissed off that we had this and I was going to start using it myself. And I did. And then, but now there is basically immunity for the counties and the states and any other political subdivision if they violate Marsys Law, which is what I always thought was the kicker, because now if they violate Marsys Law, there still is nothing that anybody really can do, which is the same thing that there was a problem in 2010 when Ramos was commuted and nobody notified the victim's family. There's nothing they can do. They can't do anything now, either way, as far as any lawsuits or things of that nature. However, all we have done is just create the burden for notification requirements on the counties. So it really also hurts, the First Amendment aspect of trying to figure out where a robbery occurred. We're trying to figure out where a burglary occurred. This whole part as far as where or when victimization occurs was interesting, because if we had, tweets, for example, the police department would send out a Twitter feed of Argus 911, and it would say that a robbery occurred at Pizza Hut, for example, on East 10th Street. Well, if they were, that Pizza Hut on East 10th Street has the right to privacy. So what they were doing for a period of time was establishing quadrants and making the city into a grid, and just basically saying that there was a robbery in section B3 of Sioux Falls, without really saying what business it was, or, obviously more if it was a home robbery, what the address of the house was. They would say the block, the 400 block of North 3rd Avenue, there was a robbery, things of that nature. And it really, frankly, got really silly, because, the police were trying to do what they can do to not disclose information. The media was trying to report on news, and there was a direct conflict. And that's where we've had a lot of issues with officer-involved shootings, not disclosing that information. We've had a lot of issues with, accidents reports. I had a lot of personal injury attorneys, friends of mine, saying that they didn't realize how Marsys Law was going to impact the civil justice system. But, if you're going to make a claim against an insurance company for property damage in a car wreck, the first thing they want is the police report. The first thing they want is the accident reports. And police departments were not giving them out because they contained victim information. And they're saying they're confidential records and we can't do that. So, it was an issue that really impacted all parts of the justice system, not just this. And the issue is primarily because people were wondering how courts were going to treat this constitutional amendment compared to otherwise statutes that rule the game. We have a priority here, and the constitutional amendment, most people thought, and I think rightly so, was going to trump anything else. So that's kind of some of the changes that were made. It was interesting in my point of view because we were telling people there were these problems. Nobody really believed us, and then they came back and said, "Oh my goodness, we're having these problems." It is better now, but we're still dealing. And it's better in the sense that they fixed things that helped other areas of the law, such as the opt-in provision allows accident reports to go to personal injury lawyers. The limited definition of victim kind of helps, but it didn't really impact or change a whole lot in the criminal defense world because we are still battling a lot of and making the new law issue by issue and case by case when it comes up. So that's the changes that were made compared to where we were for a period of time.
Yeah, I have a couple questions for you, and I want to start with this opt-in provision. Does that actually impact in criminal cases? Are victims opting in? Are state attorneys or DAs encouraging them to opt in? How is that playing out?
My understanding of how the opt-in provision works is basically they're given a Marsys card at the scene. If there's a victim and they're making the report, they're given that Marsys card, which I know is provided. But then also it's basically, do you want to be notified and your information put into this save-in system so that you're opting in to exercise your notification rights, first of all. Some people would say no, that we're not going to even want to know that compared to the other part. That's kind of the first block as far as what they need to overcome to opt in. And then secondly, I don't know what happens between the prosecutors and the victims, what kind of additional opt-in is needed. I can tell you that from my experience, prosecutors use this. If the victim is telling the prosecutor what they want to hear, the prosecutor just basically says, "Well, my victim is making me do this." If the victim is not telling the prosecutor what they want to hear, then the prosecutor says, "Well, you only can consult. I make the final decision." So it really is kind of how they're playing what the victim wants and making their decisions. Otherwise, I'm not real sure about opting in.
Yeah, I would agree.
So, and then similarly, you mentioned that one of the key points of delay for criminal defendants is at that bond phase, because under Marsys Law, victims have a right to participate in any decision concerning relief. Can you tell us a little bit more about what kind of delays you're seeing, how long they are, and again, is opt-in starting to reduce those delays, or is it just playing out the same as it was before the statutory change?
Since the change in the law with the opt-in, the time in custody has changed. I mean, the judges are granting PR bonds. Where we see the delays is under state law, there's automatically, whenever somebody's arrested, there's a no contact that is ordered. It's put in place as a condition of bond. If the state's attorney is not able to get a hold of the victim or they're not participating in the process, we're not able to work with the court and with the state's attorney to get that changed or get a hearing set so that we can argue why that no contact needs to be lifted. So if a husband is staying in a hotel room or staying with his brother because they're not participating in the process, it takes us a lot longer to get that no contact lifted. But everybody has a right to appear in front of a judge within 48 hours, and that happens irregardless of whether or not Marsys Law is in place.
I think most of those delays were initially when people were trying to figure out at the time of victimization What do they have to do? Who do they have to provide rights for, and things of that nature. Now judges will just state, well, they haven't opted in, so we're going forward.
Right. I think where you see the delays more now are with trial, where the alleged victims are not cooperating. They're not staying in touch with the state's attorney's office, and the state's attorney's like, well, I have to comply with Marsys Law. I have to give them notice. I have to, Marsys Law says I have to make sure they're notified. And it's like, you're just asking for 10 delays because you know that your alleged victim's not cooperating with you. You're using Marsys Law as an excuse.
I actually want to go back to the initial adoption because, Ryan, you were talking about creating that there was actually a pretty broad coalition in opposition to Marsys Law that included some pretty strange bedfellows if the kind of prosecutors and counties were on it. I want to ask first, how did you go about bringing about those coalitions, bringing about some of those unusual allies, and second, whether that coalition has increased or decreased as time has gone on, and has other groups come in? I can envision, for example, sheriffs being concerned if pretrial detention numbers are creeping up.
There was an interesting photo that I found when I went through memory lane and looked at some of these things. When they did the amendment Y to change Marsys Law, it was backed by law enforcement. We had chief of police was back there. The sheriff of Minnehaha County was behind there. And, basically people that we were trying to get to be more vocal initially were all on the front pages to amend this thing because they then realized how bad it was. It's how we got this arrangement. I guess initially the prosecutors were kind of timidly on board because these are elected officials. They didn't want to come off being soft on crime, but yet they have budgets, and they also, some of them are normal individuals who realized this was going to be a problem. So I think Pennington County prosecutor was much more vocal in opposing this. Our local prosecutor was much less vocal, but he still was against it, and basically because they primarily focused on budgets and what they were going to have to do when they finally paid attention to it and saw what it was going to be. The chambers of commerce and the different business entities really got involved, primarily, I would say, because there were some lawyers in our community who sit on their boards and sit on their legislative research council, committees of the Sioux Falls Chamber of Commerce has a committee that looks at these referendums and says, thumbs up or thumbs down. Well, it was those lawyers that don't really give, don't do criminal defense, but we at least notified and said, this is a problem. And they were smart enough to realize that, hey, as the chamber, we can have a bigger voice and at least talking to our businesses and try to give our opposition to this. So basically, we reached out to those people that were, I'd say, the decision makers in some of those other organizations that were going to encourage their members to vote one way or the other. I did go to Pierre. We had the state chamber. Some of the biggest hitters in the state were there, and they knew what was going on, but they also knew that they had other fish to fry. And the chamber, the business chamber, we couldn't get them. They would be opposing this, but they weren't going to spend any more efforts or money against it because there was another referendum that they were going to try to defeat first. So they had priorities that they had to do. We even had the governor at the time. The governor at the time did not want this, but he was also not going to be very vocal against it. So he had a press release. I remember getting that and being very happy, but then realizing that it really didn't mean a whole lot because he wasn't going to do much more. He was just going to say that it wasn't something. The press release was, this is not a priority, and I don't think South Dakota needs it, was basically what his press release was. But he didn't get out and do much more in opposition. I hope that answers your question.
Yeah. Tracy, you talked a little bit about some of the problems you're facing. When you have a situation where, for example, as a representative of the accused, you are kind of being barred from looking at a scene because that scene happens to be, victim's property. What do you do in that circumstance?
It involves having to file motions, setting hearings, and addressing with the court. It just, we have a high number of cases and only a certain amount of time, and it just brings a lot more work for our office. I mentioned that the state's attorney received additional staffing. They received 4 additional victim witness assistants to help them with the additional need to notify the victims, to challenge, to have the additional bond hearings, to deal with the delays, to fight for the right to have access to discovery. We didn't receive any additional staffing at all after the enactment of Marsys Law.
And are those, when you file those motions, and I will say we have an example motion under handout, are you generally successful? I mean, I know it's still resources to pursue it, but are courts relatively amenable to granting you access and understanding the due process issues?
I would say no. That motion that's in with the handout, we were not successful. The judge ruled that the police needed to go into the house and take additional pictures. They met with the attorney to see what exact pictures they needed. And then the judge said, now if you don't get everything you need, come and set another hearing with me and we'll readdress it.
I think that was a little different because it was the person's kitchen.
Yeah, I'm not sure what area of the house it was, but you shouldn't have to disclose what your defense is to the state's attorney and have them do your investigation. And you shouldn't have your investigator worried about getting served a cease and desist for, investigating a case and making 2 phone calls to a witness. And then having to have motions hearing to challenge that issue. So,
have any of those cases, any of those motions gone up on appeal? I mean, have there been any kind of upper court rulings on this kind of conflict between Marsys Law and defendants' rights to due process?
I'm not aware of any. The one example that I have is still pending, and the other one ended up being resolved, and that issue hasn't been appealed. So I'm not aware of any others that could have been.
The only case that I know of that's been up to the South Dakota Supreme Court was an issue of whether or not these rights apply to somebody, a South Dakota resident or a Minnesota resident. And our court said that they only apply to those in South Dakota.
So you have to be a local victim.
Yes.
I did want to ask another question about some of the unusual ways, the kind of unexpected ways Marsys Law has been applied. And Ryan, you mentioned in passing there was a case in South Dakota after the adoption of Marsys Law where a highway patrol trooper who shot a man, the officer's name was not released because he claimed protection under Marsys Law. Can you talk a little bit about that, and if there are other kind of weird applications of Marsys Law being used, and whether those were addressed in some of the legislative changes?
Yes, this officer involved shooting in which they did not release the name of the officer was interesting, especially because, in my opinion, I don't think it really mattered if it was before the change or after the change. But if the person's a victim, I can see how they would have the right to privacy. You have the whole issues about the person being a police officer. That all aside, is that the individual that shot the police officer was never charged with a crime. So I could never figure out how he was a victim and could invoke Marsys Law when that person who shot him was never charged with a crime. But it is something that, they pick and choose when they want to use these things. There is no doubt that my understanding is, simple assaults on law enforcement officers, aggravated assaults on law enforcement officers, just other cases where law enforcement officers are a victim, they could claim this. I don't believe it. I haven't seen lately that they have, but I know it is something where those individuals, more than anybody else, may want to not have their home address listed or things of that nature, and do so. I think that the strangest requests or the strangest time frame or issues during this time frame was the grid and the coordinates and attempting to try to figure out, the media try to figure out what to do, where they know that there was a robbery or a shooting because they can hear it on the scanner. If you listen to the scanner, they say addresses, but then they can't release the name of the address type of situation. So they were really trying to figure out what was going on. The First Amendment applications are basically implications as well, were interesting. We still have HIPAA, which is victims' privacy rights on their medical records. There's other hurdles as well too in this job to get that information, but this just added that extra layer of constitutional rights against that. I can tell you as well, kind of a little side note and bring in abortion into this. There were people that were concerned that a guaranteed right to privacy, which is, say what you want, is not in the federal Constitution, would be in a state constitution. And in a state that is very conservative and very anti-abortion, it did have some people up in arms about whether or not a right to privacy, specifically laid out, is kind of a slippery slope. So that was another aspect of basically where we're at right now. I've never seen any challenges based on that, or any issues brought on that, but it's just something also that's kind of interesting.
Yeah. Under the narrow definition, or the definition of victim, which is a point that you've talked a lot about, who is considered the victim in a murder case?
It'd be the family, the direct family. I'm trying to find the definition right now.
Okay.
The clear one. Yeah, it'd otherwise be the next of kin, but it would still be direct family members as well, that are around mothers, siblings, and otherwise the next of kin or anybody else who could be considered the executor of their estate.
And another question that we got from the audience, to what extent do you think Marsys Law has hindered or helped prosecutors?
Well, I feel like they use it when they want to aid them when it's easy for them. I do believe at times it does hinder them because they have this belief that their role is now just a lawyer for the victim and not the prosecutor, which is completely different things. I think certain prosecutors handle that individually different than others. There's sometimes, an office that their view would be one way or the other, but then when it kind of comes down to it, and when you're really pushing these issues, most of the time, I would say they understand that, they're the prosecutor, not the lawyer's attorney. So for them, I honestly think there's times where it has made their jobs more difficult, especially when the victims are now well aware that they have victims' rights and that they have constitutional rights, and the victims believe themselves that they control the proceedings. So some prosecutors deal with that better than others. They're learning a little bit of client control, victim control, dealing with individuals, dealing with expectations, dealing with, things of that nature, which they've never really had to deal with before. They go in with the file, make their argument. But now, and I know of a couple of prosecutors that tell me that, they've had to learn a lot more people skills. They've had to learn to manage expectations. They had to learn to follow up when they say they're going to follow up on phone calls and letters to people, which maybe they didn't have to deal with so much before.
Do you anticipate a broad challenge to Marsys Law? I mean, a lot of the challenges that have gone on across the country have really been on the question of whether the ballot measure itself is overbroad, and really not a lot of, almost no cases have even reached the question of the due process implications. Do you think this is going to result in more, constitutionally based challenges and appeals in South Dakota?
Right now, I would say it's more of the case-by-case basis, and that's how this is going to be litigated out. I don't know of anybody looking at a broad, not argument, but a broad attack on the whole thing. I think we've got terrible case law in the state of South Dakota regarding the nature of these initiatives and referendums. If you remember a little bit about the history, the law in this state is to make these easy to do because the people rule and the people are supposed to be making their laws, and this is supposed to be a way to do that. So once it's done, it's very difficult to change in a state like South Dakota, where a lot of the power was delegated to this process. So there's very little checks and balances on the process once it's on the ballot. I don't think anybody realized that we'd be in a situation where they would be spending an inordinate amount of money for the number of votes. Somebody can come in and just buy it, but that has been the way that it's been changed. And there has been some discussions on changing that process, but right now, we're stuck with what we have.
Has Marsys Law bar, people with expertise in this area developed in South Dakota?
Like a victims' right bar, victims' attorneys?
Yeah. Yeah. And then a follow-up question from the audience is, are victims asking for publicly funded counsel under Marsys Law?
We have seen some people ask for public defenders or ask for counsel under Marsys Law, and we have to refer them to private attorneys. It's specifically, that's one of the bad things about Marsys Law. It really doesn't give people a remedy, and it specifically does not allow for the right to counsel. So like Ryan said, he actually took one that he challenged. So we usually refer people to defense attorneys that we know will at least talk to people and hear them out. We'd like to see a good test case, but no, they're not entitled to court-appointed counsel.
What they do get is, and Tracy mentioned it, there's a place here called the Compass Center in Sioux Falls. For our clients that are charged and convicted of domestic assaults, they're referred to the Compass Center for rape and domestic abuse counseling. This facility also has a new grant that allows for an attorney who represents victims in protection orders and represents victims as basically an advocate in criminal cases. So I think there's a huge conflict of interest there. That an attorney, we're sending our clients to a place that now has an attorney that can convict them, or that an attorney that's advocating against them. But otherwise, no, as far as the traditional sense, as far as qualifying for court-appointed counsel, they do not have that right. There are, though, nonprofits that have an attorney that if they go to and say the right things, they can get them. I would also state, I brought a challenge because there's a person that I knew who owned property where a murder occurred at, and the guy has now pled. But for 2.5 years, they delayed the case. Most of the delays were on behalf of the state, actually, and not the defense. So my guy owned property that was seized, or secured, so that they could do an evidence review during the jury trial. So he was under order of the court that he could not change, or he could not even enter his living room, or enter his basement. We got it so he could enter the upstairs. So we sued, basically saying as a violation of his rights under Marsys Law as a victim, because he was suffering financial harm and because he'd rented the place out. He doesn't collect rent anymore. He's a victim. We need to get this trial done. It was resolved in other means. Not really happy to my guy, but it was just something that I kind of was, aware of what happened there, and I sued everybody under the sun trying to get something for him. And I do think this guy got the shaft, but there was, in essence, very little that he could do.
And not to try to get too in the weeds about the right to counsel for victims, but what Ryan was talking about, there being an attorney for the Compass Center, which is a group that provides treatment for both abusers and victims. As part of where we're at now, with one of the issues on whether or not we have the ability to provide our clients with discovery because it contains victim information, our local state's attorney's office has been going back and forth with us on asking the court for a standing order that in order to treat our clients, the facilities, the therapists there need our clients' discovery. So while they're doing battle with us that our clients should not be allowed to have discovery, this same nonprofit facility that is representing victims in court under Marsys Law when they don't have a right to counsel and is supposedly treating our clients, they're now claiming they have a right to discovery. But so that's what is the problem, is everybody's getting mixed messages. The state asserts Marsys Law when it serves their purpose, and then lets it go when it doesn't serve their purpose.
Oops, no, we can't hear her.
Now we can't hear you.
I'm sorry. I'm trying to look through and make sure that we addressed the questions that were raised. Oh, I did have one follow-up question that I saw that relates to people in or out of the courtroom. I assume that you're kind of arguing those on a case-by-case basis. How is that playing out? Are they allowing kind of this wider definition of victims in the courtroom, even though they're witnesses? Have you had many cases that you're actually dealing with that in like a trial setting?
In my experience, the Constitution and Marsys Law is trumping the statute that calls for sequestration of witnesses. And that's the way that the judges have analyzed the decisions, is that the constitutional rights trump the statutes, because there's nothing in our Constitution that states sequestration. That's a statute, and that takes second place.
Yeah, and they're interpreting victim very broadly.
So if you were giving advice to other states that are, looking at or facing the adoption of Marsys Law, what are the key points that you would say try and get in early and at least, if you can't defeat this thing, clarify these kind of 3 points?
The one is, I think you got to do the broad coalition like we did. You also need to do it way, way, way better. But you need to get people that aren't in our business involved so that they understand how it's going to impact them. Our county is doing another opt-out. We're raising property taxes, law enforcement, criminal justice systems, the main reason why. You can take a look at the numbers that we were talking about back then of, $600,000, $400,000, which is significant for a county in South Dakota. I could multiply that by 1,000, and you can see what it would be in a county in a larger, more metropolitan area. So when you're looking at that, and the other thing is that, as I mentioned before, this does not practically give victims anything more than what they had before. I mean, we had statutes that said this. Whether or not the person followed the law was one thing or the other, but right now there's no remedy. I could not sue anybody anymore because they're immune. So whether or not the prosecutor even follows it, it doesn't make a difference because they get sued, they don't care because they're immune from it. So practically, it provides nothing more for victims than what we had before. It only increases the burdens on the county offices.
And I would agree. I would tell people to money talks, look at the financial implications. We've seen a significant increase in staffing requirements. Like Ryan was indicating with the opt-out, we're building a brand new jail right now. And when you look at, how much you're getting for the additional cost, will anyone say that our county is any safer, our state is any safer? You know, has crime drastically gone down? Everybody always talks about public safety being the utmost importance. I don't think anybody would say that Marsys Law has made our state safer. So I think when you're talking to non-lawyers, those are the two biggest things that you can look to South Dakota and say, we haven't seen anything related to safety, but we have seen significant financial implications.
Okay. Well, I want to thank you both so much for joining us today, and thank the audience for being here. As I said at the start, we'll be sending out a recorded version of this along with the materials to everyone who registered. And I hope this provided you some additional information on Marsys Law. Thank you.
Thank you.